everybody, this is Eric Jose on Making a Murderer on YouTube. I cover the Stephen Avery and Brendan Dassey cases, but also as time passes I've been covering other cases such as the Staircase or OJ and many wrongful convictions of youth. I go over the documents, the photos, the videos, anything case related, so stay tuned because I have many more videos just like the one you're about to see. Hello everybody out there. Wanted to go ahead and upload something here today. It's something I uploaded in the past, but now with the renewed attention that MAM2 has brought and everything, I wanted to go ahead and revisit the Amicus briefs for Brendan when he was petitioning for his writ of certiorari. So this particular one we're going to see here today is the law professor's brief. I found this one to be particularly fascinating just because it was so, I mean, it was written by law professors whose business it is to know the law and what their take on the whole Brendan Dassey situation is. So that's what we're looking at today. Hope you guys enjoy it. And if you haven't seen it, I hope you really get some good information out of it. So here we go. What we're here to talk about today is the brief filed by the law professors and basically the instructors and professors that teach the law and how you investigate things, and how you basically various bunch of scholars who are very, very learned in the law and police tactics and constitutional law, essentially. Or they'll talk about something that's happened in the past with the Supreme Court, decisions they've made and things that they have ruled, and they'll take quotes from the decisions, and they will then take that and say this applies to Brendan Dassey and this is why da 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 da. So these guys, because they are constitutional law scholars, are really going into the Supreme Court case law and pulling out all of basically everything that the Supreme Court has decided that actually favors Brendan Dassey. They're actually putting it right here in this brief. So I obviously picked out some of it for you. We'll go ahead and move into it now. Here we go. In applying this test, court has recognized that coercion can be mental as well as physical, and that the blood of the accused is not the only hallmark of an unconstitutional inquisition. Basically, the blood of the accused from getting beaten up is not the only hallmark of a coerced confession, right? Okay. Further, the court has clearly instructed that the propriety of police techniques must be viewed in terms of their effect on the particular suspect in question. The court has repeatedly recognized that certain categories of suspects are particularly vulnerable to police coercion, including children and those with intellectual impairments. Indeed, the court has clearly mandated that special care be used in assessing the voluntariness of a juvenile confession. Careful attention to the impact of the police techniques on the particular suspect effectuates key principles undergirding the Fifth Amendment and Fourth Amendment and 14th Amendment totality of circumstances, namely in the psychological coercion can manipulate suspects, and juvenile confessions must be reviewed with special care. The suspect's intelligence challenges must not be intellectual challenges must not be must be also taken into the voluntariness review. And when facts are disclosed to suspects, that contamination raises still greater the reliability of concerns, particularly in confessions involving psychological coercion, juveniles, or those with intellectual challenges. In this case, both the court below and the Wisconsin Court of Appeals made grave doctrinal errors in applying this court's long-standing precedent. The circuit court below saw clear evidence of psychological coercion, the leading and suggestive nature of the questioning, the broad assurance from police that honesty would produce leniency, the guesses that petitioner had offered when investigators were not satisfied with his responses, and the non-public facts that investigators blurted out when they lost patience with petitioner, then adopted, but discounted it because Dassey was not subject to physical coercion. That ignores, or at least clearly misapplies, the well-established law holding that coercion can be mental as well as physical. One of the main themes that I noticed with the law professors here that kind of rang throughout the entire brief is they are basically going back and looking at the fact that the Supreme Court has said that number one, the blood of the suspect is not the only hallmark of an unconstitutional inquisition. You understand what that means, right? That means the blood of the suspect that would be shed if he was beat up or coerced by physical means, right? So that's what it means by the blood of the suspect is not the only hallmark of an unconstitutional inquisition. In other words, an unconstitutional interrogation, right? So that's that's a quote from the Supreme Court. Okay, that's why it's being featured so much in this brief. So what they're hammering home here is that these other courts are ignoring psychological coercion. They're just acting like it doesn't exist, and that's what these law professors are really pointing out throughout most of this. And that's what, at least that was the impression I was left with after reading it, that they are basically just saying, look, the totality of circumstances is no longer being looked at the way it was meant to be. We really need the Supreme Court to step in on this and snap these lower courts into line and make them take the totality of circumstances more seriously. Because you'll see as later on here, they actually go into citing other cases. One that was actually almost heard by the Supreme Court itself, where the prisoner, the victim of the wrongful conviction, was eventually later exonerated about 20 years later. Yikes, you know what I mean? So let's move on into the next bit now, and we'll come on back. Age alone, however, does not end the voluntariness inquiry. Rather, the application of the special care standard in the totality of circumstances test requires an actual evaluation of a juvenile suspect's age, experience, intellect, and mental state, and how these factors affect his or her responses to police interrogation, rather than merely a check-the-box approach that lacks meaningful weighing. More broadly, the court in Spano looked skeptically at psychologically coercive interrogation tactics that often produce inherently untrustworthy confessions. Likewise, Galt analyzed with greatest care the voluntariness of a minor's confessions because authoritative opinion has cast formidable doubt upon the reliability and trustworthiness of confessions by children. Similarly, Miranda was unwilling to allow trading on the weaknesses of individuals, in particular those of limited intelligence, that risks giving rise to a false confession. Establishing its prophylactic rule in part because of the dangers of false confessions, and in recognition of the fact that the assistance of counsel can mitigate the dangers of untrustworthiness. Moreover, recent research has confirmed empirically that police contamination has led to numerous false confessions and wrongful convictions of many individuals later exonerated by DNA evidence. So, you can see these guys are just kind of focusing on what has been handed down from the Supreme Court in the past, and they're applying it to Brendan Dassey as it applies. And I think it all lands very well because, I mean, Brendan, it's obvious. I mean, the way that, I mean, you saw one of the other clips I put up. Did you see the way that they were going through the Seventh Circuit Court went through the you know, kind of assurances of leniency, the you know, friendly manner, you know, all those different tactics that it mentioned, but because it wasn't physical, none of that mattered. And that's what these law professors are pointing out, that but the Supreme Court has said that psychological coercion is highly it matters. It's relevant and it can happen. The Supreme Court has already ruled that, and it's especially more likely to happen with minors, with juveniles. And that has also been well acknowledged by the Supreme Court, and that's what these lawyers, these professors of law are just hammering home. They're like, you know, look, this is not something new. The courts are just ignoring it. And that's why we need the Supreme Court to go ahead and just put the, you know, kibosh down and go, look, this is the way it goes, and get everybody to snap into line. So anyways, we'll go into our next couple segments here, and we'll come on back. The en banc Seventh Circuit expressly acknowledged the leading and suggestive nature of the questioning. The court below observed that Brendan Dassey was alone with the police, and that this vulnerable suspect had received broad assurances that honesty would produce leniency. It also recognized that Dassey had appeared to guess in response to questioning when investigators were not satisfied with what he had told them, and that the investigators told Dassey facts that were not publicly known, which he then adopted. This court has repeatedly acknowledged that purely psychological tactics such as fact-feeding, playing the false friend inducement, and making implied promises can be just as coercive as physical violence and cause a defendant's will to be overborne. False confessions of innocent suspects convicted but later exonerated have been affirmed in high-profile rulings that failed to conduct a proper voluntariness analysis. This court has considered some of these cases. In 1994, the court considered the case of Henry McCollum, an intellectually disabled man who, along with Leon Brown, a 15-year-old juvenile who was intellectually disabled, was convicted of murder and rape based on their false confessions. The North Carolina Supreme Court affirmed McCollum's conviction, finding his confession voluntary in a brief statement that barely considered the impact of his diminished intelligence. Neither the North Carolina Supreme Court nor the North Carolina Court of Appeals conducted a searching voluntariness analysis, despite the state's evidence resting almost solely on McCollum's confession. This court denied McCollum's petition for certiorari, but Justice Blackmun dissented, focusing on McCollum's low IQ and observing that there is more to the story. Justice Blackmun was correct. In 2014, over 20 years after McCollum's and Brown's convictions, DNA tests cleared them and implicated a man who had committed a similar rape and murder around the same time and who lived adjacent to the crime scene. Recently, Justice Breyer observed that had McCollum been executed, the DNA test and exoneration would never have occurred. Had the North Carolina courts done more than a cursory voluntariness analysis, McCollum's confession, the centerpiece of the state's case, may not have been admitted, and he likely would not have been convicted. Unfortunately, McCollum's and Brown's case is far from unique, and failure to identify involuntary confessions can prolong convictions of the innocent by years or decades before exoneration, if it ever occurs. Moreover, a series of DNA exonerees who falsely confessed had similarly been denied relief when trial, appellate, and habeas courts rejected challenges to the voluntariness of their confessions, or otherwise rejected challenges implicating the confession evidence. Indeed, some of those courts rejected challenges raised by subsequently DNA exonerated innocent persons, citing that the very details that we now know were the result of police contamination. As evidenced by these cases, and by McCollum's case, if state courts conducted appropriate voluntariness analyses as mandated by this court, some of these confessions would never be admitted and innocent individuals would not be convicted. So, I think the professors of law and forensics and stuff, I mean, just, wow. Awesome, man. I mean, the way that they're citing the law here, going back into Supreme Court decisions and pulling out those things which support Brendan and explaining how the things that are supposed to happen according to the Supreme Court with the voluntariness test and all that, basically the totality of circumstances test. Just everything that they're pointing out, going back and all the things that the Supreme Court has said about the totality of circumstances test, everything that the Supreme Court has said about psychological coercion and the fact that it's a real thing and it's not just some fairy tale. So now, is everything psychologically coerced? No, the Supreme Court's not going to say that. But I think there's a good chance that they're going to see it here. I think there's a fair chance they're going to see it here. I mean, so many of us do, right? So many of us see it, that Brendan is clearly floundering and guessing and just way in over his head in that interrogation. It is plain as the nose on your face. You know what I mean? So, anyways, that about wraps it up for the law professors, folks. I hope you found it interesting. I know I did. And we'll be seeing you later. If you haven't already, please hit subscribe.